Welcome back, everyone. It's Peter Tragos, the lawyer you know, and today we're jumping back into one of our old favorite cases, and that is the R. Kelly federal criminal case, where he was convicted of RICO charges surrounding a ring of sexual abuse that they went through in the U.S. Attorney's Office, convicted R. Kelly of that, but now we are hearing some rumblings and getting some filings of appeals and motions for new trial and them trying to overturn or vacate this jury verdict. So today, and this is by popular demand because a lot of people have been asking about it, and there was a lot of interest in this case during the trial. So we are always here to try to break down what the people want to hear, and you have asked to talk about some of these motions. So on today's episode, I am going to bring up one of the motions filed, and this one really focuses on the actions that they're calling very ineffective by R. Kelly's defense team. And basically, they're filing this motion for new trial, arguing that the defense team was totally ineffective and violated R. Kelly's constitutional rights. So we're going to talk through that motion today. If you enjoy this R. Kelly content, please make sure to hit the like button on the video so I can know how much time to kind of put into these. And give me your comments, give me your questions throughout the entirety of this video and all these R. Kelly videos, because that's really how we build this content. And this is just more proof of that. As we're going to dive into this document today, I have not read the entire motion. I'm going to read it here with you for the most part. I've skimmed parts of it, so I know kind of how they set up these kinds of motions, so we can skip through parts of it. We're not going to read all 22 pages. We are going to get to a lot of meat here. Some things may surprise you. There's a lot of things in this that I didn't know about because obviously we weren't able to watch the entire trial since it was in federal court. But let's jump into this document now and talk about what it says, what it means, and whether or not we think it has merit. All right, so this motion was filed on February 17th, 2022, so a little less than a month ago, and it is defendant's motion for new trial. Okay. And as we get to what they're asking for in the beginning of all of these kinds of motions, this is kind of like an appellate brief. There's a lot of research. They're applying the facts to the law and to other cases and the rules of law and how they would overturn this verdict and give the defendant a new trial. So there's a lot of that in here, but the summary of the argument comes right here on the first page of in the table of contents. Number one, the defendant was denied effective assistance of counsel, where his trial attorneys failed to conduct a meaningful voir dire of potential jurors and challenge unqualified jurors, some of whom had watched the inflammatory docuseries Surviving R. Kelly or were familiar with prior accusations of sexual abuse of minors against defendant. Counsel's objectively unreasonable performance during voir dire resulted in the impaneling of a jury that was neither fair nor impartial. That is striking to me, especially on this show, as we talk so much about voir dire, about picking a jury, about how important it is, and about how all of you could be potential jurors. So this, to me, is pretty shocking, and if true, could potentially rise to the level of granting a new trial, because as we know with the Glenn Maxwell case, a fair jury is one of the most important things you can have in a trial. Argument number two, defendant is entitled to a new trial where one of his attorneys labored under a disabling conflict of interest as a result of her simultaneous representation of the defendant and the government's star witness, Jane, that was imputed to the entire defense team. So we're going to find out what that relationship was like with this lawyer representing Jane, one of the star witnesses. We'll hear what they represented her on, because that conflict in itself is not going to overturn this verdict. But if that conflict actually did create a problem that was imputed to the entire defense team, maybe it could. So again, on its face, these are good arguments. And just so you know, every one of these, I shouldn't say everyone, most of these motions and appellate briefs, if a lay person or just anybody that doesn't know anything about the case was just to read them, you would think that they are going to win, because both sides make good arguments and find cases that say what is compelling for their argument. So as you read through these, I expect you to nod your head and think, yeah, that makes sense. That makes sense. They're probably going to win. But what's really important in these cases, and we're just going to skip through you can see all the cases that were cited and the rules that were cited. This is how you just kind of set them out, the constitutional provisions that were cited. But what's really important in these cases is the legal standard. And the legal standard provides that upon the defendant's motion, the court may vacate any judgment and grant a new trial if the interest of justice so requires. For us, that makes sense. For lay people, it's like, yes, we need justice. But it confers broad discretion upon a trial court to set aside a jury verdict and order a new trial to avert a perceived miscarriage of justice. But such discretion should be exercised sparingly. And it really has to rise to a high level. And this is a very high and difficult bar because we don't want judges overturning jury verdicts because the Constitution says a jury of our peers is going to decide our fate. And they have done so in R. Kelly's case. So in order to overturn that jury's verdict, it needs to be something that only happens sparingly and few and far between. So legal standards are very important. I wanted to read just this part of the introduction. This motion identifies two serious violations of the defendant's Sixth Amendment constitutional guarantees that require a new trial and are apparent from the record. First, again, they reiterate, defendants were ineffective, especially in voir dire, and the conflict of interest. So, point number one, which is we're going to talk about whether or not these defense attorneys were incompetent or ineffective based on their voir dire strategy. But to set the stage, let's remember this is federal court. And we've tried cases in state court and federal court. You all have followed cases in state court and federal court, but you've only watched jury instruction, most of you, in state court, where you hear the lawyers asking a lot of questions and the lawyers digging in, the lawyers making motions. In federal court, it is very different. And you'll even hear as they describe it in this motion, I'm sure. The court is the one asking most, if not all, of the questions to the jury. And the defense attorneys and the government attorneys can make suggestions to the court, can ask the court to ask certain questions and do certain things, but the court doesn't have to do it. So that's a different kind of action and work done by the defense lawyers, where if you don't ask any questions in voir dire in a state case, that's pretty rough. But if you're just not pressing the judge over and over again, it may not rise to the same level of ineffective assistance of counsel. Additionally, if you don't ask the judge to do certain things and you don't put it on the record, you hear me talk about so much protecting the record. If you don't ask the judge to ask certain questions and there's no record of it, then that can be held against you as a defense attorney that maybe you were ineffective. So I don't know if we're going to hear maybe from the government's argument, but I bet this attorney's not going to say, well, the defense asked certain questions to be asked, but the defense attorneys allowed certain jurors to be on this jury that they believe absolutely were unqualified, not impartial, not fair, and should have been struck for cause. One of the other issues, and again, hopefully I'm not throwing too many legalities at you, but cause strikes should be brought out by both sides and the judge. So all three parties, if somebody should have been struck for cause, should have seen that and struck them. A lot of times as we start jury selection, when we meet with the judge and the judge will say, lawyers, I think these 5 jurors should be struck for cause. Any argument? So the judge is also looking for cause challenges. So as we read these, you're going to think, this is obvious. They should have been struck for cause. The judge is not going to agree with that because that would be saying that the judge also made mistakes throughout voir dire in not striking all of these jurors for cause. We're going to talk about rehabilitating jurors and all of that as we go through. But I want to set the scene so you know that federal jury selection is different than state jury selection. All right, so here's just some legal arguments citing some cases about due process, about our constitutional rights to a fair and impartial jury. Here we go. Guaranteeing criminal accused fair trial by a panel of impartial and indifferent jurors. Rule 24 of the federal rules also protects that. And it provides that if the court examines the jurors, it must permit the attorney for the parties to ask further questions that the court considers proper or submit further question that the court may ask if it considers proper, which is what I just explained. Here it is in rule form. Trying to go a little more quickly through this. The trial court's duty to ensure that each and every juror is fair and impartial. All right, so now we're going to get into some specifics about the case and what happened. The questionnaire contained an entire section entitled Knowledge of the Case and People that asked jurors to reveal whether they had read, seen, or heard anything about the case, the alleged crimes or people involved, and to describe in detail any information they had previously learned by the defendant. The questionnaire expressly asked prospective jurors whether they had watched or heard any interviews of R. Kelly or any TV shows featuring him or any specials or documentaries about him. We all know what documentary they're talking about. The court invited counsel for both the government and the defense to review questionnaires in advance. And that's true. A lot of times we get these questionnaires in advance. We get to review them. We get to strike some for cause or write in or know who we're going to strike for cause or know who we wanted to ask some pointed questions to based on their questionnaires. That was allowed in this case. And again, they were asked to agree if certain jurors should be excluded for cause. And they did that, and they identified a set of potential jurors. However, inexplicably, defendant's counsel failed to challenge several jurors who ultimately sat on defendant's jury, who were clearly unqualified to serve on account of their preconceived beliefs about defendant's guilt. These decisions cannot be justified by a trial strategy where the record fails to reflect that trial counsel conducted a sufficient inquiry to probe these jurors' biases. Indeed, trial counsel was mostly silent throughout voir dire. Again, their silence throughout voir dire is very different in a federal case than in a state case. The questionnaires were highly effective tools for putting the parties on notice of jurors who might not be qualified to serve. And we talked about this in the Glenn Maxwell case about how important these jury questionnaires are. And we're going to hear some answers that are going to make your ears perk up. Just like the juror answered incorrectly on Glenn Maxwell's case, in R. Kelly's case, it sounds like they answered truthfully, but still got on the jury. And we'll talk about how that's going to be so different than the Maxwell case. All right, but trial counsel made no effort to drill down on troubling representations that demanded further inquiry to ensure the juror could be fair and impartial, regardless of general assurances that he or she provided to follow the court's instructions. So this is the difficult part where our hands are tied in jury selections, where we believe somebody's going to be fair and impartial. If the court or the U.S. attorney follows up and rehabilitates the juror and says, all that, you bring all that. You've heard of R. Kelly. You've seen this documentary. You don't think he's a good guy. Could you put all that aside and be fair and impartial? Well, if that juror says yes, theoretically, they're no longer a cause challenge. Now, I don't always agree with that, and we've gotten some struck for cause even after they've said yes, they can be fair and impartial. But some judges, if the juror says they can be fair and impartial, even if they said my mom's the victim, sometimes the judge will let them on. And I don't think they should, but sometimes it happens like that. All right, so perhaps most troubling is that several of them saw the surviving R. Kelly and they said they could remain indifferent, but let's get to some specifics here. And this is where it gets crazy. Juror number 3 provided the following information in the questionnaire. Question 29. The case for which you're summoned involved the defendant, R. Kelly. Have you read, seen, or heard anything about the case, alleged crimes, people involved? I watched the documentary, but I forgot the name of it. Have you ever read, seen, or heard about R. Kelly? I heard that he has been sleeping with underage girls. Have you watched or heard any TV or documentaries about him? Yes. What were your general impressions? I saw a documentary about him and his legal troubles. I don't know the full story and I have no feelings and remain impartial. Do you know anything about the Me Too movement? Yes, a movement seeking justice for rape victims 25, 30 years after the fact. Now, the most damning ones are that he's heard he's been sleeping with underage girls and he's watched the documentary. But again, not necessarily a cause challenge. Trial counsel did not ask the court to question the juror further about his responses to these questions. Not a single question was asked of the juror about his impressions of the documentary, nor did counsel ask the court to inquire further about what information he learned about the defendant's prior legal issues or his reputation for sleeping with underage girls. Frankly, anyone who's seen the documentary should have been automatically removed for cause. I don't necessarily know if I agree with that just because they've seen the documentary, they should be removed from cause, but I definitely ask for them to be removed from cause, and if they wouldn't, I would ask for a preemptory challenge. And again, at some point, I assume this video hopefully is not going to be 2 hours long. We'll get into how you have to protect the record when asking for peremptory challenges. Juror number 4 revealed in the questionnaire. It involves exposure to one or more sexually transmitted diseases. Is there anything about that that would affect your ability to be fair and impartial? Yes. So yes, this would affect their ability to be fair and impartial. I find the transmission of STDs to a non-consensual act to be particularly repulsive. So, yes, they are going to be impartial on the questionnaire. Good argument for a cause challenge. Have you known anyone that was a victim of sexual assault and that required medical treatment? Yes. Close friend received asylum due to sexual assault and infection with HIV from the police in a foreign country. Which publicly known person do you least admire? Very interesting question on the questionnaire. They said Jeffrey Epstein. Now, I don't know why that would strike them for cause in the R. Kelly case. I mean, I get what they're going for, but I wonder if this was on the Ghislaine Maxwell questionnaire, because that would be a cause strike probably for a Ghislaine Maxwell case. I don't know about for R. Kelly, but this person, kind of like juror number 50 in the Ghislaine Maxwell case, has some experience, at least a close friend does, with sexual assault, and they made it on the jury, which is proof to all of you out there who say it's impossible. They can make it on the jury. I don't think that this person should necessarily have automatically been struck. I do think there should have been some follow-up question about the fact that they said their experience with or their feelings on the STDs could make them not be impartial, but I don't think this should be a cause strike in my opinion. So again, although the court asked generally whether anything the juror read would affect their ability to be fair and impartial, they said not that I know of. And just so you know, malingering or going back and forth is not going to be good enough in voir dire. You have to be certain you can be fair and impartial. You can't say probably, you can't say I think so, you can't say not that I know of, things like that. So this juror eventually said they could be fair and impartial, which according to the court was good enough to not strike them for cause, which is why I don't think juror number 4 really rises to that level. Juror number 3, on the other hand, reputation for underage girls. Let's hear more about that. Juror number 5. Have you watched any of the documentaries? Yes. What were your general impressions? He loves underage girls. Loves underage girls. Do you have a general impression of the defendant? Yes, it's somewhat negative. Why do you feel that way? The allegations that related he was sleeping with underage girls, in parentheses, minors. I do not know how this person got on the jury. Juror number 3 and 5. I mean, to me, this should be a strike challenge. Cause challenge, sorry. Although the court asked the prospective juror general questions about his ability to put aside other things they may have heard, when asked they could be fair and impartial, the juror indicated they would give it a shot, which in my experience has not been good enough. The court reminded the juror that he or she had to be certain that she would consider only evidence offered at trial, and the juror acquiesced. Incredibly, the court seemed very concerned about this juror's ability to be fair and impartial, observing, so I don't know about you, but when someone says they think they can do something in a context, I don't think that's an unqualified assurance. And the court is right. However, we still ended up with a I think so, and let me hear from the government if you have anything on that position, if you have a position on that. Not surprisingly, the government was confident they could be fair and impartial. Trial counsel did not do enough to challenge this juror. And it even says, had the trial counsel tried to challenge this juror for cause, the court seemingly would have struck him or her for cause. Now, again, in my experience, the court doesn't need a lawyer to strike a juror for cause. The court could have done it on its own if the court felt it rose to that level. But again, they may not be wrong that if the defense attorney would have then asked for it to be a strike for cause, maybe the court would have done so. Juror number 7 revealed in his questionnaire, he heard about the case. He heard about the documentary and the case, and the court just said, can you put it aside? Juror number 8 also said they heard about the crimes the defendant allegedly committed. Again, trial counsel failed to probe what precisely the prospective juror had heard. Juror number 9 heard that the defendant had issues with the law, couldn't say for sure. Me Too is a power structure of the male-dominated movie industry and maybe movie industry has been turned on its head. Juror number 11 disclosed they saw the case mentioned on the news, allegations of misconduct lodged against him. Again, usually you don't want people that have heard about these cases beforehand, but when you have a public figure, things like this, having heard it on the news, having feelings about the Me Too movement, maybe not the best jurors, and maybe someone you want to strike preemptively. With a preemptory challenge as a defense attorney, but I don't think they necessarily rise to the level of a new trial. 2 of those jurors, though, pretty bad. Juror number 12 offered several concerning responses. Have you read or heard anything about this case? Yes. Describe what you recall. Sex with minors. Specific details do not come to mind. Parodies on TV regarding details of the defendant's personal life. SNL, Dave Chappelle, etc. Was in jail prior, then released. And when you go into this level of detail, you probably want to strike this juror. Have you read, seen, or heard anything about R. Kelly? Yes. Same answer as above. Various instances of achievement in musical career, songs, video, news shows. Specifics are not remembered. What are your feelings or general impression? Somewhat negative. Why? The somewhat negative impression is an emotional one impacted by the nature of the charges against him. Again, more Me Too feelings. When inquired about the jurors reference the defendant's personal life or sex with minors or SNL or Dave Chappelle, defendant videotaping sexual encounters that depicted him urinating on a minor, a crime for which he was prosecuted, although not convicted. That is a level of detail that should not be on this jury, in my opinion. It's beyond comprehension that trial counsel would not have sought to inquire further. Allegations against the defendant are pressed whether he could be truly fair given the information which he came to the jury. Nearly all of the alternative jurors admitted they were aware of the allegations against him. And critically, alternate juror number 4 revealed that she was aware the defendant was married to Aaliyah when she was young, but claimed she had not really heard much about the case and assured she could be fair. Notably, this juror apparently was familiar with the well-known Me Too lawyer Gloria Allred, who represented some of the government's witnesses and asked if she could get her autograph in the middle of the trial. Wow. The defendant had no chance to defend himself, or most of the jurors in this case were fully aware of his legal problems. Here, they get into some of the case law about how critical voir dire is. Not going to get any argument from me. Defendant received ineffective assistance of counsel, failed to conduct meaningful voir dire. Trial counsel's performance was unreasonable under the prevailing professional norms, where he failed to question these biased jurors. Trial counsel belatedly sought to remove the juror, stating, "I can't think of anything more disqualifying than a juror asking for an autograph of one of the attorneys that represents the witnesses. It speaks to bias, and for that reason, I would ask that she be removed." And that request was denied, which should tell you a lot. Okay? Find out about the autograph, about how this juror is a fan person of one of the victim's attorneys. They asked for an autograph in the middle of trial, which is totally inappropriate, and they were denied to strike them there. Trial counsel was, of course, correct that this was biased. Defendant was prejudiced. Okay, so we're going to pause here, and I may cut this into 2 videos before we get to point 2. Let's just talk about point number 1. All right, so based on what you've heard just from point number 1 and what this defense counsel did or didn't do during voir dire, if you think this rises to a level that this trial was so unfair that R. Kelly needs a new trial, write new trial in the comments. If you don't, then write no new trial. And I think it's really important that one thing I didn't see in this argument and throughout the first point of this motion for new trial is whether or not defense counsel tried to use additional preemptory challenges, asked the court for additional preemptory challenges for some of these jurors for which the court denied in order to protect this issue for appeal. Because if they didn't, that would be more ineffective assistance of counsel. Now, they did say that the defense attorney did nothing, and maybe by doing nothing, they mean they didn't even try to strike him for cause, because first you have to try to strike him for cause. Then you got to try to use one of your preemptory challenges, which you can strike him for any non-discriminatory reason. And if the judge denies that, or if you run out of preemptory challenges because they're limited, you have to ask the court for another one, tell the court which juror you'd use it on, and if they challenge what reason for being non-discriminatory, you have to give them a reason for why you're challenging that juror. And if the judge still denies it, that's fine, but you have now protected it for appeal. So if they say they did nothing to try to strike these jurors, and they include no even trying for cause challenges, trying for preemptory challenges, then I think that's a pretty good argument for a new trial, or at least protecting it for not protecting it for an appeal. But this bar is so incredibly high to get to prove ineffective assistance of counsel, which is sad when we think about our criminal justice system. And most people think just rich people get good lawyers and they get off. Well, these were not cheap lawyers. These were not free lawyers. These were lawyers that R. Kelly chose and paid. And again, that's going to be used against him because he had the right to fire these lawyers. There could be something to do with strategy as to why these lawyers let these jurors on. And the judge is not going to overturn or grant a new trial based on legal strategy that didn't end up working. And just as you saw, in the middle of the trial, they tried to get this juror removed who asked for an autograph, and the judge denied that. So just because it sounds really bad to a layperson, just because even it sounds really bad to a defense lawyer, doesn't mean it rises to that level to be one of the cases that should be sparingly granted for a new trial. Now, I think the jurors that said they had a preconceived notion that he slept with underage girls and loved underage girls, and they watched the documentary and they had a negative feeling about R. Kelly, it boggles my mind how they end up on the jury. So for those reasons, I'm kind of leaning towards giving him a new trial. But at what point do we let clients and lawyers make these legal strategies throughout the case? Because the lawyers were there. They were doing stuff. Obviously not enough. So I'm kind of torn at this point, and it's not a beyond a reasonable doubt standard, okay? Let's remember that. I'm torn, which usually means it's probably going to get denied. But I think if I was the judge on this case, I would probably grant this motion for new trial. So that's going to be part one of this motion for new trial. I don't want to have these videos be too long. I will come out with a part two for this motion for sure. But if you guys want me to break down further post-conviction motions, we'll call them because they're not really appeals. This is a motion for new trial. If you want me to break down future motions, please make sure you like the video and let me know in the comments. But for now, that's all we've got for part one of R. Kelly's motion for new trial. Thanks for watching this episode of The Lawyer You Know. If you like this content, please share it with your friends. Make sure you subscribe to our page and like our videos. If you want some interaction, get in the comments and we'll be sure to get back to you. If you want to know any more information about our firm or this page, you can find out in the description or visit tragoslaw.com. We post multiple times throughout the week, so make sure you hit that bell so you can get the notification and not miss out on the next episode.